All right, so thank you again to everybody. I know there's many thank yous to go around, but thank you especially to Robert and the organizers from the journal, and for their tireless work and all the stuff that comes with putting together a symposium like this and also a volume on franchising. With all the experts in the room, I guess one comment I would have is if Robert had extra hats, Cindy and I would need what I would consider a beanie with a little propeller on top, since we are the newbies in the room. You didn't ask for it? Okay, it's probably in your box over there. But we have expertise in other areas, but we're really excited to kind of jump into the idea of franchise and try to bring what will hopefully be a fresh perspective, something different, so sort of our newbie kind of not Pollyanna, sounds negative, but with our sort of fresh perspective on this, and maybe come at it even looking over some ideas about encroachment that have been covered before, but hopefully give a fresh, positive perspective from where we come from. I do a lot of work on employment contracting and covenants not to compete. I also teach business ethics, so there's that element there in terms of where we talk about a little bit of culture and trying to increase the positive nature of the ongoing relationship of franchisors and franchisees. And I do some corporate governance stuff, but Cindy is really deep into the corporate governance material as well, and she wishes she could be here, but it's the great thing about partnering with an excellent co-author who's very active and a great colleague. She's always around the world teaching and doing all kinds of interesting research in other places. So lucky for me, I was able to step in. So really long outline, this is what the paper will someday look like. Or it looks like this now, but I'm not going to bore you with all the details. But I do want to spend some time kind of in the middle and towards the end of it, sort of applying our ideas about corporate governance and a little bit about restrictive covenants and the way those are analyzed as a way to give some new life maybe to this idea of addressing what we see as this misalignment in franchise or franchisee relationships. Okay, so this stuff's in the news. Even as a casual observer of franchises, I'm seeing stories about wage and hour issues and new government regulation there. As has been mentioned before, protests from food service workers around the country, and this misunderstanding of who the employer is, if it's the franchisor, the franchisee, that sort of thing. My adopted home state of Michigan, where I teach at the University of Michigan, people have thought a lot about this idea of auto dealerships, and after the financial crisis and the bankruptcies of the auto industry, how those dealerships may have been an outdated franchise model, and whether or not they had a property right issue as well. Saw something recently about Tesla. Can Tesla Motors sell directly to customers in New Jersey, and why New Jersey and franchise interest there may try to stop that kind of movement. So it seems that there's a lot of those stories going on, but there's also just this underlying idea that franchise activity leads to a lot of potential for economic growth and employment, when we sort of get out of this long-lagging recession and lack of jobs for lots of folks. So when we think about this at the start of the franchisor-franchisee relationship, both parties seem to have similar financial interest in profitability and growth. So this has been mentioned before. Their interests seem to be aligned. It's all rosy. People go into the contract with the best of intentions, and they both, fortunes rise with the rising tide together. Okay. But there seems to be these perennial problems with the ongoing relationship, and so some of our work here in thinking about how to apply other areas of law to the franchise law context will get at hopefully those problems of the ongoing relationship. So what happens after the contract is signed? And these misalignments are things like the contract issues we've heard today from other speakers, certainly fairness and equity issues. I teach business ethics, so I think a lot about the bargaining, the leverage issues. That's always a claim with non-compete agreements that employees are forced into these contracts of adhesions, and that has been mentioned here today as well. Market encroachment claims. So Robert said earlier that these seem to have dropped a lot. There's an article, his article, we cite a ton, the encroachment article from a few years ago, where he went far as to say that encroachment is something that remains, in particular for numerous franchise systems as a whole, the issue that is most in need of a just resolution. So that sort of ideas about material disclosure, disclosure, obviously something that comes up a lot in corporate governance and shareholder education, that sort of thing, really set off our antenna. So Cindy and I thought we'd kind of latch onto this as well. So it's just not to say that market encroachment doesn't happen or it's not a main issue. It sounds like it's been resolved a lot by contract language. So there's an evolution in terms of the way the contracts addressed it, but the actual claims or the problems of having a franchisee's business area encroached upon, as you know, with innovations like internet sales, even just the classic geographic problem of a new establishment nearby, those issues remain. So Our perspective is that the misalignment of interest going in the ongoing relationship, i.e. post-contract, can be alleviated with concepts from corporate governance and the law of restrictive covenants. So that's kind of our thesis and a long way of saying what the rest of the paper is about. All right. Which is to say, to not treat the rest of the relationship like an arm's length agreement. I know sort of that is the mode of the way things go, but we've thought a lot about in other papers that we've written about corporate culture and law and the effect of law on positive business relationships, and it seems to be that this is conceived of an ongoing relationship as just more of a point, and this is the relational contract point. There's a lot of work that could be potentially done in improving the relationship for both parties. Excuse me. So there's the problem, the misalignment problem of the interest. Certainly that's stuff that comes up in the FTC approach and the new rules. The implied covenant of good faith cases show that that's kind of been not a great way to resolve these sorts of disputes. But there are certainly things we've talked about. So this is kind of a quick outline from the paper. Franchise disclosure requirements going beyond the UFOC. Various categories of disclosure, things like requirements now of saying the nature of the franchisor and the franchise system, the financial viability numbers, issues about costs involved in purchasing and operating, the ongoing costs of the franchise outlet, terms and conditions that governance the relationship, and certainly things like other folks you can talk to who've run those franchises before. And then we do focus on the paper in some extent about the reforms under the amended rule in 07, things like e-disclosure, the delivery timing, the litigation disclosure stuff we just heard about from Chris in great detail. And of course, this one, the warning about the lack of exclusivity if applicable. Right? So that's a big one, right? So that goes directly to the encroachment issue as well. Okay. So in terms of critique, some of this actually lovingly poached from Robert. First point about doesn't solve the post-contract incentive issues. Obviously, a potential problem there. The second one, disclosure alone does not create the best relationship. So that's something we can get even from corporate governance law in general. That our point is disclosure just by itself for the sake of more information. We've heard about this today. The information overload potential problem really means that if there's not a collaborative action going forward, the parties may not actually find that disclosure meaningful, right? And it doesn't actually say anything about the quality of the relationship. It just says there's more disclosure, which is a basic point to start, but not the entire relationship. Okay. So I'm going to take a fresh look about importing corporate law duties, fiduciary duties in general, into this relationship between the two parties. So the classic corporate governance problem is divergence of interest and incentives, right? So owners versus agents, agency problem. And so there's a bunch of ways that can be handled. Which are contractual ways, deferred incentives, that sort of thing. But that one's always there. And then we focus a bit in the paper talking about specific ones that are obviously often tied to directors and officers rather, but we're looking at things like the duty of care, right? So, this one, act reasonably, be informed and deliberate, duty of loyalty, obligations of good faith and candor, act in the best interest of the party, avoiding corporate opportunities that belong to the entity, that sort of thing. So really thinking about these duties of good faith and how they actually set up a good set of incentives. So beyond the hard regulation, these are softer things that are there that courts will later go on to apply to the situation, but are about more applicable to an ongoing relationship. Okay. So what's some benefits of these? These are well recognized. They are also concepts to recognize the superior bargaining position of one party over another, an issue that comes up obviously in the franchise situation, asymmetries in knowledge and leverage. But admittedly, these concepts have had a hard time taking root in franchise law and even beyond these relationship statutes that don't go as far as setting up these types of duties, but do go beyond mere disclosure. All right. So restrictive covenants piece, a little bit different in an area of law that's by no means perfect or beloved by all areas. It's interesting to be in California where employee restrictive covenants are not allowed, but certainly with the sale of goodwill of business they are. We thought this might be a way to start to look at the relationship. So if you start to impose duties where they don't exist before, how do you actually sort of set up a balancing of where these come into play? So certainly with franchise agreements, there's always, or franchise in general, there's always, teach this in class, there's always issues about antitrust, right? So they're, by their nature, anti-competitive, things like market allocation, something you also see with any sorts of restrictive covenants, right? So they're already viewed with some sort of askance look about the quality of these agreements, but they're allowed, and they've been historically allowed, and have a long history of litigation going back hundreds of years. So these are things like confidentiality agreements, non-solicitation, poaching, newer concepts of garden leave, paying people to stay out of the workforce so they don't compete. But also, the one we focus on is employee covenants not to compete. So looking, there's, the general reasonableness balancing test, which you think you can apply to some of these fiduciary relationships as applied to the franchise agreements or the franchise relationships. Okay, so limited in scope, particularly geography and duration. So the class encroachment problem has a geography component, right? So we think that actually may be a good fit to look at it that way, and the way those are balanced to give both legitimate business interests, but balanced against the public policy incentives of avoiding undue hardship, making sure there's not overreaching. So the overreaching is where you might see that in terms of the worst case scenario with a franchisor who doesn't necessarily look out for the best interests of their contractual partner, right? So they have the right to do that by freedom of contract, but we're hoping there's some other ways to look at it and to balance those. And we think there'll be some good outcomes in terms of the productivity of the relationship. So benefits here, it's a well-trod, albeit evolving area of law, right? So there's lots of law, sort of guidance to how courts have looked at these in the past. Courts are good at applying this balancing test. And it really has some analogous points to the overreaching through encroachment, much like the overreaching that employers are accused of in the employment context when they are trying to reach out past the entity and stop employees from competing after employment is over. And and the fairness and justice issues as well that we've talked about in other contexts. All right, so decided to draw some theoretical benefits, or some rather theoretical conclusions from these. Look at the benefits of if this is the way the world is. So I've talked about, there's the problems to getting to this point, but this would be like where we would think it would be an excellent way to get the relationship in terms of making it more positive and profitable for everyone. So from the corporate governance side, so there's the basic concepts I talked about, the fiduciary duties. We would say courts have franchisor and franchisees currently are seen as separate entities, right? So there is a logical jump there to try to think of them as more of the ongoing relationship. The relational contracts thing extend out. But the extent of control matters and the bargaining disparity matters. So, establishing a fiduciary duty relationship, there's certain things that matter, right? So things like the amount of control, if they're acting on behalf of both, or if the principal is acting on behalf of both or on its own. If they have a common interest in profiting from. And a big one is this element of domination control, right? So often apparent in the corporate governance situation, but also in the franchise situation as well. So in our world, we like the ideal. So the best situation would be if they would be built on trust and confidence of both parties. And similar, but more useful than just mere disclosure. So where our argument is ultimately sort of, we want to move towards a world where there's more than just disclosure, beyond disclosure, in terms of to support the relationship. And then in terms of the CNC, the covenant not to compete, reasonableness evaluation, and the encroachment problem, like I said before, it's how do you get to the next step of evaluating one way around encroachment by valuing whether the encroachment is really encroachment or is it something else, right? So actually measuring what that would be. Engaging in a reasonableness analysis, focusing on the geographic restriction and scope issues, focus on legitimate business interests and exceed limitations on competition, but make sure they're acceptable within reason. So it would take a new shift to think about where those limits are, and it would go beyond just strict contract reading as well. All right. So in some ways, it's sort of like if you were in the enlightened state or in the enlightened franchisor, what policy would you want to create the best positive relationship between the parties? So it leads us to our conclusion about some potential policy implications. All right, so the state of affairs is currently the imposition of fiduciary duties, and the use of a reasonableness evaluation of encroachment is, to put it lightly, resisted. So if you look at the court cases, and many of you have, it's going to be a tough sell. But nonetheless, again, the paper's about theory and what direction we'd like to push these relationships in. However, we still think the benefits outweigh the cost of just sort of giving up and saying it's unlikely to happen without some major changes. And again, it'd be something that states could do as well. And so there's some benefits, the potential to reduce conflict between the parties, give more meaning to the current disclosure regime, so adding more details to what I've described as the mere disclosure situation, where there's lots of information, but it maybe isn't as useful, without having the parties be able to use that information and use it together. And then also maybe provides incentives to limit encroachment, or another way to look at provide penalties if encroachment occurs, since there may be more regime to evaluate that in a new paradigm of looking forward in the relationship, and also encourage longer-term thinking and collaboration beyond the initial contract formation. So this is the ex-post situation, thinking where they should go, and so that's I think an extension of the existing relational arguments as well. And it provides a mix of possible interventions to shape behavior and provide recourse for the parties. So in some ways it ends up being, or sort of argument ends up empowering franchisees more, but we're okay with that in terms of the balance of power where we see it as it sits with the current contract situation. All right, so that's a quick overview. I don't want to stand between you and an exciting panel, but I'm happy to take questions and feedback and input on what is a developing paper. Yeah.
As you were writing it, were there any other areas that you kind of came across? I know you're kind of new to franchising, but was there any other area that you started to see maybe something in and saying, oh, that would be another issue kind of ripe for examining in the corporate governance context?
Trying to think, that's a good question. Nothing comes to mind. One of these things we're trying to limit the scope in a way, so it doesn't get too far beyond, and try to both be a little provocative about trying to import ideas from a different area of law to this area of law. Certainly something that I didn't know how to work in, but that I think about a lot, especially teaching, is like, it came up today too in discussion, codes of ethics and professional codes with regard to these separate organizations. So that's an interesting one. And someone commented this morning how sometimes those end up taking life and becoming more solidified in the law. So I think that would be interesting as well. So part of these are like, what would be described as more broadly like a new governance concept of self-regulation, right? Which goes against some of what we're saying, but if the market had those kinds of incentives for the companies to work for the franchisors to work more closely with franchisees and continue to have a positive relationship, which does happen in some concepts, right? So clearly, where the market's incentives are aligned, where even after the contract is signed, the rising tide lifts all boats, as opposed to the incentive to try to overcrowd and overreach, right? Those incentives are still there, but I think it's a balance between giving some governance back to the entities and let them run with it, but then knowing that they may be really opportunistic, right? And part of it, and I see this with lobbying for things like the non-compete statutes, and there's a lobbying story in terms of why this came up earlier in discussion as well, about how and this is we saw the maps earlier this morning about different states have different types of policies. And I think that's really interesting because it says something that there's some lobbying going on, but not as an industry. So it doesn't seem to be a real industry, which cuts both ways in terms of getting laws that focus on either side of the party, right? Or having some state legislators incentive to go ahead and craft a new set of laws at the state level, right? Because from what I can tell, the FTC isn't interested in going much further and probably has lost some stomach for this already. So reforms are not probably forthcoming at that level. But part of this thinking, if you were in an enlightened state, how would you want the world to work? And so thinking about those types of incentives. Yeah.
Just a couple suggestions for the future. I've actually never seen other work done on the relationship between corporate governance and franchise. That's new to me.
Yeah.
Think about that. And I think there is some fertile area to look into further. One, on your encroachment, one of the reasons why encroachment claims have been reduced is because many franchisors began adopting what they call market impact studies, so that they could study the relative effect of one encroachment versus another on the system. So your principle that the best interest of the entity should guide
So is that driven by technology and better metrics for understanding?
Better
Okay.
metrics, but they were also getting nervous about these plans. So it was a smart thing to do. Second, the International Franchise Association is doing some things that you ought to look into. They have created a new group mixed between franchisor and franchisee members to take a number of initiatives to produce what I think you would probably call good corporate governance, including coming out with a document which would be distributed, which would essentially take what has become the very much lawyer-driven gobbledygook of disclosure documents and turn it into something which tells prospective franchisees, here's what's important to look at, and here's what's less important. And there are a whole series of things like that, and you might want to look into that for purposes of further work on the corporate governance aspects of franchise. That's a couple suggestions.
Yeah, and we didn't come across a literature that talked about how the business structure matters. So I mean, that's kind of which is sort of a technical, like how do you best set up these entities on both sides and the benefits. Yeah.
Couple suggestions.
Absolutely. Thank you. Good. Well, thanks again to everyone letting us dip our toes in a new area and hopefully add some outsider's value to the thinking that goes on already. But it was a really good experience for us. And as we work on it and expand our footnotes, definitely send me more information if you come across articles, or if you're the guru, you've probably written another one since I cited your last stuff.
There definitely are things when Phil was talking about the
Okay.
first point in terms of more these market studies, which obviously is really in the self-interest too of the franchisor. You know, saying, look, you know, we've got these studies that show